The layered approach to legislation is an innovative tool of easification of legislation, which aims to contribute to its intelligibility by all three user groups. At the moment, the structure of a text, of a legislative text, is seen as a mere technical or drafting concern. I would say that structure is more text-centered at the moment. So we look, on the basis of Lord Thring's teachings, we look to introduce a text that has a logical sequence. The question is whether structure really is just that. And my impression is that we have until now undervalued, underestimated the role of structure in the easification of complex legislative texts. I think that the sequence of provisions can enhance the receipt of the prime message of legislative communication. Why? Let's look at advertising as a model. This is where the main message comes very strongly in the very beginning or within a short period of time. We know that our audiences, and I'm not just talking about legislative audiences, I'm talking about readers of a written text. And so legislation is a critical case study because it is much more complex than normal legislative and non-legislative texts. So we know that the attention span of our user ranges between 4 and 7 minutes. Within those 4 minutes, we have a prime time within which we grasp our user's attention. And this is the short period of time that we have in order to convey to them what the main regulatory message is. So if I am introducing legislation to convey a benefit, there is no point in telling my user that a new benefit is being introduced, that it is open to people under a certain number of requirements, and it is enjoyed by following a specific process, if it takes me more than 4 to 7 minutes to do this. So placement of these important regulatory messages in the very beginning of the text promotes not just the concept of primacy, their importance, but also promotes the opportunity that lay users give us to actually receive the message in question. I'm talking about lay users because group 2 audiences, so non-legal professionals, are used to legislation. So they are more tolerant of longer texts. And then lawyers and judges are trained to deal with those texts. So I have no doubt that lawyers and judges will continue to read legislation much beyond the attention span that a lay user could afford us. Now, there is already evidence of this approach in the modern structure of UK acts, but also acts within the Commonwealth. So it is obvious to me that most modern legislatures introduce legislation that and legislative texts that are bare of preliminary provisions. These tend to now come at the bottom of the text as final provisions in order to allow the first schedule, the first section, or the first article to be present in the very beginning of the text. The use of schedules is another example, or annexes is another example, because again, they allow the drafter to bear the text from too much information which might be technical or procedural in nature and detracts from the main regulatory messages. However, all this movement has not been formalized or extended to the actual structure of the body of the text. At the moment, provisions in the body of the text are prioritized on the basis of their nature as primary or secondary. substantive or administrative, general or special. I'm referring to Lord Thring rules. But to achieve easification, we actually need to move forward. We need to depart from a text-centered approach to structure to a user-centered approach in structure. So we need to identify the specific clusters of users for this specific legislative text. So we know that we have laypersons, we know that we have non-legal professionals, we know that we have legal professionals as users, but there are specific, more particular types or circles of users for each text. And we need to not just identify them, but also identify what questions they will be asking, what answers they expect, and also what messages we want to give them to each and every one. And on that basis, we can then proceed to dividing the text into 3 parts. So part 1, and this is something that current legislation very rarely has, part 1 speaks to lay users. It expresses the main regulatory message, and it uses unsophisticated language. I think Scotland is an enlightened model for a part 1, because a number of Scottish texts are using you in order to speak to lay users directly. So part 1 is what is missing from normal legislation now. There is, in my view, no time and no place for pomposity in legislation. It is there to be functional. It is there to speak to lay users. So let's use this as a channel of communication. Then we move on to part 2 of the layered approach. And this is where we tread on familiar ground, because at the moment, legislation is drafted to speak also to regulatory professionals, to convey additional specialist data, and of course, it uses semi-sophisticated language. And I think especially in the UK and in most modern legislatures, this is what this is the level, this is what we're experiencing. This is the level of the pitch that legislation presents today. And then finally, in part 3, we can speak to legal professionals, we can use legal data, and we can use legal jargon. And this is so incredibly liberating, both for audiences, because they finally have, or they will have, a communication that they will understand, a communication that will readily answer their questions, but also liberating for drafters, because they can express complex legislative concepts in their own language. One of the main criticisms of the plain language movement is that it is impossible to express intent in plain language, and it is. But it is not necessarily important for a lay user to understand intent in the detail that a lawyer or a judge should. The burden of proof is not something that should concern lay users or even non-legal professionals. It is certainly of concern to lawyers and judges, and they can, through the easification of the text, through the layered approach, they can finally discuss it in the terms that have long been established, that carry with them case law, that carry with them detailed, sophisticated interpretation. So what is the layered approach? The layered approach supports the introduction of a single text. I'm not talking about 3 versions of the same text, a single text with varied level of regulatory communication addressed to varied user groups, using language with varied levels of sophistication accordingly, that promotes understanding for each and every of those 3 user groups. And of course, from all of this, I think it becomes quite clear how important the layer approach can be as a tool of approachability of legislation. Approachability of legislation is not just a constitutional wish. It's not just there to promote the benevolence of policymakers. Approachability is part of Bingham's rule of law. So it does touch upon the foundations of democracy and the rule of law as we understand it. It is a right for our citizens, and it is an obligation for those of us who draft legislation on behalf of the state to be able to provide it and promote it. I understand that the layered approach seems quite unfamiliar, but it isn't. If we depart from my pitch and we look at Lord Thring, we're not doing anything particularly innovative. At the end of the day, what I am suggesting is that we start with substantive law. I'm using Lord Thring's terms now. We start with substantive law. We continue with procedural legislation, and then we move on to the details for lawyers and judges. So it is not new. What is new is that we are putting the user at the center of any decisions, that we are prioritizing regulatory messages on the basis of who should be receiving them, and most importantly, that we use the language and the tools that are required for each of the three groups. Is this important? Absolutely, because it is one of the unique tools that are available to us as drafters, as lawmakers, even as policymakers. At the end of the day, legislation is a tool for regulation and policy. So it allows us to finally unlock the problems of plain language and really talk to our users. And of course, the best way of ascertaining that we've done a good job is via user testing, taking samples of each group. It's awful to talk about people using the term samples, but taking a number of people as samples of the user group and asking them questions to ensure that we did actually convey the message that we want to convey. And that takes us all the way through to consultation, but that's a different, completely different topic. So the layered approach, to get back to the question, is an impressively unique, exceptionally promising tool to open a direct channel of communication between the state, the law, and its users. It can be revolutionary. It is already starting to happen, but not to the extent that I would like, and not to the extent that it can.